County. So, away from that, and let's head to the corridors of justice, where the Court of Appeal has begun hearing the National Assembly appeal on contentious laws passed without the input of the Senate. The Senate had gone to court after the National Assembly excluded its participation. Lawyer Steve Ogola now joins us to discuss what this appeal is all about and what outcome is expected. Joining us virtually here on KTN News Center, Wakili, good afternoon, and thank you. Not News Center rather, but News Desk. Wakili, thank you so much for joining us here on KTN News Desk this afternoon. I'm so used to News Center, but I'm on News Desk because most of the time we've had a discussion on News Center, but nevertheless, let's continue with our discussion this afternoon. So the National Assembly, these 23 laws that they passed, the Constitutional Court said they ruled against it due to lack of consultation, those need to get the input of the Senate Assembly. So what do we need to expect, the outcome from that case at the Court of Appeal?
Thank you, Brenda. If you look at Article 110, Subarticle 3 of the Constitution, what the Constitution provides is that the speakers of the National Assembly and the Senate must consult and make a decision whether a bill originating either in the Senate or the National Assembly concerns counties. This consultation is more needed if the bill is originating from the National Assembly, because the National Assembly has a broader legislative mandate. Now, if the bill concerns counties, then a decision needs to be made that it be passed by the National Assembly and then be taken to submitted to the Senate for approval. This was not done. Why? Partly because the speakers of the National Assembly and the Senate have not formed a joint standing committee. I think we've said before that to operationalize the provisions of Article 110, 111, and 112 and 113 that touch on the shared legislative mandate in the bicameral parliament, there is need for the Speaker, Justin Muturi, and the Senate Speaker, Ken Lusaka, to establish a permanent standing committee on legislations so that these bills are processed quickly.
Right. Apologies for that. Some technical hitch from the side of lawyer Steve Ogola, but I understand he's back. Wakili, you're back. Kindly continue talking to us.
Apologies, I was using my phone.
No problem. No problem.
Allow me to take that again. The Speaker of the National Assembly has not established this joint committee together with the Speaker of the Senate. So the buck stops with Ken Lusaka and Justin Muturi. Had they established a permanent standing committee comprising of senators and MPs consulting before a bill is debated and passed in the National Assembly, that committee would be advising whether that bill concerns the Senate or not. But because that was not done, the National Assembly passed 23 legislations without consulting the Senate. And the Senate went to court, and the High Court agreed with the Senate that those bills ought to have been processed by the Senate as well. This is not a good case for appeal, although the appeal is here. The hearing of the appeal is already underway. I would have cautioned the National Assembly or discouraged them against appealing this judgment. This is not an antagonistic winner-take-all kind of legislation, kind of litigation. This was the kind of litigation seeking clarification. So when you see the National Assembly appealing the judgment, it shows that the National Assembly actually was not acting in good faith. Because had they been acting in good faith, as soon as the High Court determined that those 23 pieces of legislation passed without the concurrence and approval of the Senate, they would have quickly established a joint committee to look at the bills afresh and then submit the bills to the Senate for approval.
All right. If I look at some of the bills that, the court nullified, say that, you have to get the sentiments of the senators. I'm seeing the Public Trustee Amendment Act. There's also the Computer Misuse and Cybercrime Act. There's also the Tax Laws Amendment, the Finance Act, the Appropriation Act, the Capital Markets Amendment Act, the NYS Act. So many acts that touch on counties that needed the approval also from the Senate. But then, Wakili, this is not the first time. We are seeing both the Senate and the National Assembly, assemblies actually being embroiled in if I may say, a tussle on what laws should involve both houses and what laws should only involve a certain house and leave the other house. And the senators have always felt like the National Assembly has always belittled what I may say, I may call it the upper house, which is the Senate Assembly.
I think you are right. This is not the first time the Senate is litigating against the National Assembly, but I think the more important question of political relevance is this. Why is the National Assembly continuously disrespecting the Senate? Because you may consider this as a sibling rivalry, but it has taken a lot of time since 2013 when you had the first Senate elected. We have now, 8 years later, we can now say that we have gone past what you may consider a period of constitutional turbulence. Being not knowing what is right and what is wrong, we are learning on the go. Can we really say that the National Assembly is still learning on the go 8 years later? I think there is value, there's some credence for those who claim that the National Assembly is trying to undermine the Senate. Because as I've already said, Article 110, Sub-Article 3 of the Constitution provides in clear and unambiguous language, Brenda, that a bill touching on the counties, for it to be considered by the National Assembly, there's need for concurrence between the Speaker of the Senate and the Speaker of the National Assembly. This has not been done in respect of the 23 bills.
All right. Wakili, well put forth by you, and I totally agree with you. But then, on the other hand, it's so interesting to hear the National Assembly claim that senators are overstepping their mandate and duplicating the roles of Parliament.
Well, that is now what you may consider as historical hangovers by the National Assembly, trying to protect its staff or trying to expand its staff as to exclude the Senate in participating in legislative processes. In any case, that claim or that allegation that the Senate is encroaching or expanding its legislative mandate is unfounded and unjustified and already has been disallowed by the High Court. Because that is the argument that the National Assembly put at the High Court. They told the High Court that the bills that they have considered and passed do not affect the counties. And there was no need to subject or to submit those bills for approval and consideration by the Senate. The High Court rejected that argument and held that those bills, one way or another, affect counties and the Senate ought to have been involved. So for the National Assembly to claim that the Senate is expanding its legislative mandate, I think is a bit dishonest. But I think the more important question of constitutional relevance is this. Why can the Senate and the National Assembly, through the two House Speakers, establish a standing committee, Brenda?
In fact,
if there was a standing committee, everyone would pass through the standing committee, and a decision would be made whether that bill implicates the mandate of the National Assembly, the Senate, or not.
In fact,
the standing committee, you would have senators in that committee and members of the National Assembly in that committee. Then there will be no need for litigation.
In fact, Wakili was about to ask you the same question, because after the High Court, the Constitutional Court gave a ruling that the decision taken by the National Assembly, after the National Assembly passed the 23 bills, is null and void. Why was the leadership of the National Assembly, members of the National Assembly, members of Parliament, finding it so hard to urge the Speaker of the National Assembly, Justin Muturi, to talk to his counterpart, Kenneth Lusaka, of the Senate Assembly, to form a standing committee as a way of solving this issue once and for all, instead of going to the Court of Appeal, because they've also gone to the Court of Appeal. The argument is this is becoming too costly in terms of having this case here.
First of all, I think it's just a clear case of lack of respect for a co-equal legislative arm of government. The National Assembly must learn to appreciate the role of the Senate. They must learn to respect the input of the Senate in the legislative process. It is not the Senate claiming a space that has not been allocated to it. It is the Constitution that has designated the shared mandate between the National Assembly and the Senate. The Speaker Muturi is not doing a good job in terms of providing leadership to clear the impasse. By insisting on appealing the judgment, it means that even as they appeal, there could be several legislation that are under consideration in the National Assembly which will not be subjected to the Senate because of this unrepentant, arrogant attitude by the National Assembly through the leadership, Justin Muturi. So I think they need to calm down, they need to climb down and learn to cooperate and collaborate with the Senate if the legislative agenda of Parliament being the Senate and the National Assembly, is to be advanced. Because as it is, first of all, it is not a good defense by the Speaker, National Assembly, to say it will be costly to declare those laws as unconstitutional.
Right.
If a law has been declared as unconstitutional, everything done under that law before the declaration of unconstitutionality is deemed to be lawful and unconstitutional. But from the date of declaration of unconstitutionality, it means that implementation must freeze until such a time the Court of Appeal has made a determination. We are not going to wait longer, 3 months. We will lose 3 months as we process the appeal. Actually, we have already lost 1 year, because you remember this is July. I think the High Court nullified or declared these laws unconstitutional sometimes around June or July last year.
It was in October last year, Wakili.
In October last year.
Yes.
So we're almost doing 1 year. The Court of Appeal will take about 1 or 2 months to deliver its judgment. By the time we get the judgment from the Court of Appeal, 1 year shall have lapsed. In that 1 year, implementation of the 23 legislations must be frozen.
Right.
If the High Court judgment is to have meaning, implementation must be frozen. But why freeze implementation for 1 year? When Justin Muturi could call his counterpart, Ken Lusaka...
In a minute, as you wind up.
Justin Muturi, even now, he can still have a caucus with the Senate Speaker, agree on the sticking issues, submit the bills to the Senate, let the Senate consider them, and then let them be approved by the Senate, and then implementation continues. But what we are seeing is a grandstanding, flexing muscles to be able to show that the National Assembly is stronger than the Senate. This is a classical case of the grass hurting when people are fighting.
All right, thank you so much, Steve Ogola, a lawyer right there.